Hey friends, before you go on that green card, things are starting to get really interesting with U.S. immigration. Can Donald Trump give you a green card? Hey guys, before you file for your spouse, Hey guys, come on in, type in freedom now. Welcome to today's show. I have some breaking news that I will be covering before we dive into your questions. Say hello and where you're watching from. And if you're joining today on Facebook, certainly share this with your feed. McBean Immigration TV, it's great to see you guys. Say freedom now, freedom now. Good to see you, Esther. Let us know also where you're joining from. I hope you had a terrific weekend. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law, where we believe in freedom. And that's why we're here. This is what this is all. It's all about freedom for us and for our clients. So reach out to us, guys, if you have an immigration case or problem that you'd like us to look into for you. Our phone number is right here on the screen. You cannot miss it this time. It's 914-898-9488, or you can email us as well and let us know when you'd like to meet with us, and someone from our team will contact you. Okay, contact you to book an appointment. It's great to see you guys. I'm active, quite active on social media. If you have not plugged in or followed me yet on Instagram or TikTok or Facebook, certainly do so at McBean Immigration Law. Now, let's get into some breaking news, okay? I'll start with this. Breaking news from Newsweek. It has to do with the fact that the Trump administration has converted the CBP1 app, which was an app that was created under the Biden administration to facilitate appointments by individuals who were in their home countries, primarily Central American countries, to be able to have an appointment at the U.S. Port of entry with someone from Customs about their desire to come into the United States through a parole program. And so quite a bit of individuals use this app to enter the United States, and they're at risk right now, as you may have heard from me and other sources. They're at risk right now for an expedited or a fast-track deportation process, or being issued a notice to appear in immigration court to go into a longer process to remove them from the United States. This app is now converted into a self-deportation app, okay, called the CBP Home app. They have converted CBP1 app into CBP Home app. And according to Newsweek, they are allowing illegal immigrants the chance to notify the government that they are self-deporting. And this app it's now available in the app stores. It's available in the app stores. And now the Newsweek article also says that those in the country illegally or who have had their parole revoked following the ending of certain protections are being given the chance to tell the Department of Homeland Security that they are self-deporting. And DHS has said that if they use this app, they will face harsher consequences for return to the United States, harsher consequences such as detention or expedited removal. Now, friends, before you I always tell individuals who are considering leaving the United States, it's fine to leave, of course. However, understand the consequences for leaving. And if you'd like to understand how you could potentially come back to the United States lawfully, an immigration attorney can go through the process with you. Okay, so before you decide I'm going to leave, get some information, read blogs, watch videos, individuals or speak with a lawyer one-on-one to understand how you can return to the United States lawfully in your situation. Because for individuals who just self-deport without getting information first, some of them are shocked to learn that they're barred from returning to the United States for either 3 years or 10 years. So get the information that you'll need before you self-deport. So that's one interesting breaking news. The second news is latest news, okay? Latest news. And it has to do with the fact that ICE is not doing a great job meeting the standards set by this administration to deport people. As a matter of fact, they are actually falling short of the goal that they have set. And the Biden administration, on average last year, deported about 57,000 people per month. And under this current administration, during Trump's first month in office, as Reuters is reporting, they've only deported 37,660 people. And the president is growing really anxious about these numbers and how slow and hard and difficult it is to deport people. And so Kristi Noem, the Department of Homeland Security's secretary, has shaken things up a bit as far as leadership is concerned, and made changes with the acting ICE director and the deputy director. And guys, get this, because I thought this is they're having a hard time finding people. But as far as the new acting director, Todd Lyons, he's the former assistant director of field operations for the agency's enforcement arm. He is now ICE acting director. Makes sense. He has a lot of experience. He's been in the agency for years. But then the deputy director of ICE, Madison Sheehan, who is the secretary of the Louisiana Department of Wildlife and Fisheries, and also had worked with Secretary Noem as a former aide when Secretary Noem was the governor of South Dakota. So that's who the deputy director of ICE is right now, someone who comes from a wildlife and fisheries background. Guys, this is evidence to me that they really are confused. They don't understand what to do. They are having problems finding qualified people. And also along those lines, the Department of Homeland Security, the Department of Justice, the immigration court arm, so to speak, called EOIR, the executive office, has they offered individuals this layoff package, and about 50 people, including more judges, guys, are leaving. And it makes no sense, because who is going to be there to do the work efficiently, to make decision on the cases, to either deport more people or to grant them relief? So they're letting these people go. And then if you have your case an appeal pending, well, guess what? You're going to face a longer wait with your appeal, because the agency, the department, they're letting people go. They're letting them walk out the door. Okay, next, let's see. And then the last news two more news. The third issue has to do with USCIS and the immigration forms. Last week, for those of you who are working on an immigration case, you might have heard the news that with no notice, the department had last Monday, March 3rd, they out of the blue told us that we need to now begin using a January 20th edition of these forms, which had huge consequences for cases that have been filed and en route to USCIS's office. Those cases could be rejected or denied. And so it created a lot of stir. And the agency has never done that before. There's always a grace period. And so the American Immigration Lawyers Association, with another firm, sued the government, sued them last week. after contacting them saying, hey, you guys can't do this. This isn't how it works. You can't do this. And they didn't respond. And so they sued them. And within 24 hours of the lawsuit, USCIS changed its game and said, okay, there will be a grace period now. And so, and they will not be rejecting the forms that are in the earlier edition. So for most of these forms, you'll have it's a 30-day grace period. You could check USCIS's website to see the new edition and when you must begin using the new edition, but there is 30-day grace period for most of these forms. So that's great. Litigation is working. And there's a lot of other good things happening on the litigation front to fight against these Trump policies. So just know that some good things are happening as well. I have a video that will be coming out to you guys this week about a major shift or change with respect to how they're treating applications that are filed. It's called the NTA, Notice to Appear policy. You might have seen videos on TikTok about it. I'm breaking it down for you. The video has already been filmed. It's with our editor right now. And so if he can get it out to us, we can get it out to you this week, okay? So stay tuned to learn more about this NTA. With that being said, let's go into your immigration questions today. Type in freedom now. Okay, so a lot of these questions, I'm going to start skipping over questions that I've been answering every week, okay, just to have some variety here. Bruce is asking, can an undocumented immigrant travel to Florida by plane? So Bruce, right now the TSA has on its website a list of documents that you could present to them in order to travel around the United States. And if you have one of those documents, you could fly to wherever you want domestically. It's, of course, a at your own risk scenario these days because of all of the different things that are happening, that we hear individual stories here and there at the airport. Going to Florida. Florida is an aggressive state at this time. They have a very aggressive draconian law there in Florida that they're trying to figure out how to implement and coordinate statewide. You can watch my other videos about what's going on in Florida. Okay, thank you guys. Freedom now. Let's see. And I'm asking that you do not leave just comments, particularly if you see things on the other side or a different view. This isn't the forum for that. We're just going through immigration questions. If we just see comments, we will be deleting just the comments, okay? So let's see what we can do. Someone said, Marcos says that I applied in November for the marriage case, the marriage process. 2 years and months of marriage. Today on the website, the interview changed to completed. Will I not need to go to the interview? So here's when you should go to an interview, when you get an interview notice from the government. When you get an interview notice from the government, you need to show up. And if you're ever confused about whether or not to appear, if you've gotten a date from the government and things have changed and you're confused and you're not sure about things, to be on the safe side, common sense as well tells us just show up, because you never know if there was a glitch in the system and you got a message or a notice that you should not have gotten, and if you don't show up and they say, oh, but we told you to show up on March 10th, 2025, where were you? And you say, oh, but I saw something online that said I didn't have to show up. Well, you're most likely not going to win that argument unless you're speaking with someone reasonable who would be willing to reschedule. So to be on the safe side, you show up. Absolutely show up when they send you an interview notice with a date on it and location. Freedom now, Michelle, good to see you. Let's go. All right, let's see. I have a deportation order. I have my I-212. It was approved, and I am waiting on my 601A. If ICE detains me, will I have a right to see a judge? So here's an individual who has gone through the deportation process already. A judge made a decision on the case, and you have the 212 approved, and you're waiting on the 601A. We would be making an argument for, obviously, New Jersey, we would be making an argument for your release, number one, from detention. That would be what we would be looking to do there. I think that you would be able to have a process, an opportunity reasonably to say to ICE, it would really be to ICE that you have a case going and that they should use their discretion to release you. That's what we would be focusing on. But the judge you went through the process in immigration court. You're not in the judge issued that decision against you. If you're very concerned about it, obviously work with, I don't know, you may have a lawyer already, talk to your lawyer about it, or you could talk to us one-on-one, but I would be focused on your release, all right? Let's see, Freedom Now, guys. And the text is small. Let's make it a little larger. Is it normal that I have not received a work permit yet? My I-130 was sent last July, and the rest was sent. What's the rest? What's the rest? Adjustment of status with your work permit application. That was sent in December, and I did my biometrics on February 18th. You're gonna get your work permit very soon. You're right. You're on track. Okay. The work permit is not connected to the I-130 from July when you started the process. It's going to be connected to when you file your green card application, 485 application. All right. Hey there, Janet. Thanks for being with us today. Will it be this is a question about falsely claiming to be a U.S. citizen. Will I have a problem if I ticked U.S. citizen on an I-9 form 10 years ago to my employer? I was terminated after 2 years of employment, and my daughter will petition for me for a green card. What should I do? So individuals in this situation should speak one-on-one with an attorney, but on the green card application, it will ask you if you've ever claimed to be a U.S. citizen at any time for any reason, and you did. And so saying yes to that answer is what you'll need to do. But just know that once that happens, the government has a process of then going deeper, calling individuals in for an interview to learn more about the circumstances and to give them an opportunity to explain what happened. But the government will deny the case. And then under this new NTA policy that I'm speaking more about later this week, under this new policy, they will issue a notice to appear in immigration court. But you could speak one-on-one with an attorney to find out what options you potentially have for relief outside of your daughter's process, because there is no waiver through the family process that you could apply for having falsely claiming to be a U.S. citizen. All right, Freedom Now. Thank you. Freedom Now. Let's see. Let's keep going. Thank you. Hey there, Odami. Good to see you. Thank you for being here. Laura is asking, how much yearly income should you make for a U.S. citizen spouse to sponsor the I-130? So how much income should the U.S. citizen be earning, right? Because the U.S. citizen is the sponsor and the petitioner. You could find this information, Laura, by Googling I-864P as in Paul, and it's going to pull up USCIS's chart on the income requirements. The income requirements is determined by household size. So it just truly depends on how many people are counted in the petitioner's household and where where you're living as well. Where in the US are you located? And also, is the petitioner in the military? So look at that chart. It's really a great, fast resource. I used to do an annual video about the income changes, but with all of the Trump policies, I've only been focusing on major changes with immigration policies. But go to Google and then put in I-864P, and you will see that chart. The threshold is based on the poverty guidelines, HHS's poverty guidelines. So the threshold is actually pretty low, okay? And if your petitioning spouse does not earn enough income for this, there's other ways of going about it. Maybe assets could be used. We do that regularly for some clients. Or the other way of doing it is to have a joint sponsor. But you as the, I don't know if you're the beneficiary's income is irrelevant in this particular context, all right? What about special immigrant juvenile process? Angela's asking. That process is still okay and fine. It works. If you have a youth in your life who could benefit from this process, guys, get the case filed. Get it filed. We work on these cases as well. Glenda, good to see you. Let's keep going. Freedom now. Freedom now. Let's see. I don't want any comments. Let's go through the two questions. Okay, my daughter came with a B1 visa for treatment. Her dad won the DV lottery. But she could not return home to be interviewed. And then the dad later filed an I-130 for her. So the reason she could not leave to go back to the embassy for an interview by the deadline in September is because if she left the United States as a visa overstay, I don't know how long she overstayed, she could be barred for either 3 years or 10 years. So now the dad becomes a green card holder. The dad filed an I-130 for her. So depending on her age, it depends on which category. She'll potentially be an F2A or F2B, and she will need to wait that lengthy time and then do a waiver. She's eligible for it through her father, and then go back home to complete the process. Mary says that my son filed an I-130 for an adopted child. He needs help. Called your office about a month ago, but I haven't gotten an answer yet from your office. Mary, what answer are you seeking from our office? Are you seeking an appointment? Because that's where we start. Did you already have a consultation and you're waiting on a post-consultation follow-up? I'm asking, Mary, that you clarify that, but certainly you could email us, and I'll inform the individual who manages all of our emails to be on the lookout for your email with information about what went wrong and how we could assist you, because we want to make sure that you're being served, okay? So we'll be on the lookout for Mary's email, okay? Thank you. You could email us at info@mcbeanlaw.com. It's right here in this broadcast. Let's keep going. Freedom now. Okay, so for positive information, you check out what I shared on Friday about how we were able to help our client get a green card, right? That video is gone everywhere right now. It's doing really well, so that's some great news. In addition to great news we shared on Sunday through our newsletter about another client who got through and that client's story. So that's where you could get that. By the way, friends, I just want to mention to you that the Trump administration has created all of these laws, okay, and rules and policies. I had no hand in it, all right? So if you don't like the message, you can just unfollow, because it's counterproductive, okay? But the message will still be delivered because people have a right to know what the government is doing. And for those of you who can bear it, you stick around. If you cannot bear it, then unfollow, unsubscribe, and just go somewhere else. But for us here, we're going to stay connected to empowerment. All right. So come on in, type in freedom now, freedom now, freedom now. Let's see. Yes, the military process tends to be a lot faster, and they do help their members with the immigration process. All right, let's go down. Wilson says, what will happen to those of us who filed for our foreign wives a year ago? So Wilson, your case is still being processed. I don't know if the I-130 has been approved yet. The I-130 process slowed down, unfortunately. Once it is approved, then the visa center process is still intact. It's just that, unfortunately, the U.S. embassies and consulates abroad are expecting a major slowdown due to the layoffs that they have to do. And guys, the State Department is revising or revamping or getting rid of, they said this already, the Foreign Affairs Manual, which tells them instructions on how to do everything, including process your visa cases. So that work is going on behind the scenes at the Department of State as we speak, because it's based on the One Voice executive order that President Trump signed just a few weeks ago, and I have a video out about the One Voice. So that's how Wilson, it will impact potentially your case and other cases around the globe. All right, let's go. Hey there, Melissa. Freedom now, freedom now. If you file a case online, if an online application is available for you, you will get your receipt notice immediately. Okay, immediately. But if you did not file a case online, most people get a receipt notice within 2 weeks, 3 weeks. It just depends on the case. For some people, it will take several weeks to get a notice, but generally speaking, it doesn't take very long for most people. Angela is asking a question about the fact that they just got married and her husband's TPS will end on April 2nd. So that sounds to me like the Venezuelan one, although there's a way, I won't talk about litigation potentially connected to the Venezuelan TPS, but it ends April 2nd. Should we file ourselves so that the paperwork is submitted faster, or hire a lawyer, because lawyers are busy right now? And so for some lawyers, many lawyers, they have other cases ahead of yours. And if you want to just jump in and say, I want my case filed next week because his TPS is ending, it's very difficult to find a lawyer who is available to do that. So you don't want to wait. Now, if you decide, you could file it on your own if you choose to. It's just harder now. It really is harder to prove a genuine marriage. I published a video today about the fact that it is more challenging. Even if it's a genuine marriage, it's still going to be a challenge because of how the agency is thinking about immigration at this time and how they're trying to orient their staff to think about it from a fraud detection lens, right? That's what they have to put on for every case now, fraud detection in a stronger way. So I recommend for most people, obviously I'm a lawyer, I have a stake in this, right? So you might say, well, she's just saying that because she wants the business. I will tell you this, Angela, yes, we want the business, but we are doing okay? And we work with those who we're supposed to work with, all right? And we still turn people away each week who do not who aren't a great fit for us. So it's not that situation for us like that. So my advice is based on a genuine place. And the genuine place is that I think that people should work with an attorney on a marriage case because of the scrutiny and because of this new notice to appear policy that says that if any of your case is denied and you don't have a lawful status in the United States, they will place you in removal, or they may place you in removal. All right. Denise, I'm sorry, is asking, what is the difference between undocumented immigrant and illegal? Denise, some people have an answer for that. For me, I don't see a difference. To me, I do not see a difference. It's either you have lawful status or you don't. Other people get into the differences and the nuances. For me, I don't spend time on that. I just think that focus on getting a lawful status. Okay? Let's go. What's happening with pending asylum cases? So here's an update. I actually have something to say about it this week. That's from spending time with a very thoughtful colleague on Saturday. So with asylum, guys, there's a significant backlog. Significant backlog, as you guys know, with asylum offices across the country backed up for years. And what's happening, though, in some places like New Jersey Asylum Office, they are actually more efficient now, and they're calling cases in for an interview. Why? Because there's nothing happening at the border anymore. There's nothing really going on with the influx of people coming in and all these asylum cases from the border. Things have slowed down tremendously, and so it is freeing up their time to be able to review your cases and call you in for an interview. So, but that's not happening everywhere across the country. But some places like New Jersey specifically, that's one that I've heard has, they've really started to get things moving again. Okay. So the border, what's happening at the border does impact what's happening on the interior with how they're processing cases, particularly asylum cases. D says that I filed an I-130 and I-45 for my husband who is detained. The judge did not tell us to send it directly to her, so she requested expedited. She requested something to be expedited. Then the I-45 was done within a week. Is that a good sign? I'm not sure. Hard to say whether that's a good sign. I'm not sure how the judge is thinking about your case and the chance of success there. Freedom Now again. Let's go. Let's see. My wife and I have been here for 24 years, overstayed our visa. Our son is autistic. He's 19. If any one of us gets stopped by ICE, can we start processing for our son? I'm not sure what you mean by start a process for your son, but if either one of you are stopped by ICE and you want to make an argument to be released, then your son's condition can be used at that time as an argument to be made. And it's going to be up to ICE whether they're going to agree with the argument or not. Let's see, let's keep going. Let's go down a little bit. Freedom Now. Let's see what this is. It says, I was deported in absentia. Okay. Can I request a 601 pardon? My son is a U.S. citizen, but is 18, will be 19 in September. My ex was a citizen, but we are divorced. Okay, so you used to be married to a U.S. citizen. You have a removal order in absentia. You have a son who is a U.S. citizen, son who is 18. So your pathway to lawful status could potentially involve your son once your son turns 21, and he'll be eligible to file for you at that point. Your removal case will need to be reopened, which I think will be the more challenging part of your case, to get it reopened by an immigration judge in court, by a court. I'm not so sure why you've mentioned the 601 waiver and how the 601 waiver would be connected to you. What is that issue of inadmissibility that you've been told would require 601? The 601 waiver, depending on the type of case it is and what the waiver would be used for, generally, it requires a parent or spouse who's a U.S. citizen or a green card holder, unless it's a different kind of case, like maybe VAWA. We would also be looking at, if we were looking at this, what happened with your marriage? Were you ever abused in the marriage? You're now divorced. You just got divorced, so it's under 2 years. So we would be looking at whether anything's there for VAWA. We would be screening for VAWA, which would be could be a stronger pathway to a green card for you. But the removal case, we would also have to handle. You would need that to be reopened. Hey there, Curvia. I'm just checking in, and I applaud your good work. Thank you. Let's X out of that. All right, freedom now. Can you Can you live outside of the country with your green card? No, you cannot live outside of the country with your green card. You would be abandoning your residency. Okay. Maurice says, my I-130 is approved. My PD request is pending for 6 months in Miami. That's a long time for Miami. Any hope? Maybe. It just depends on the strength of that PD case, because the government, although, ICE is being tougher these days, they have not gotten rid of PD opportunity entirely. It's really just a case-by-case basis. That's how they're thinking about it. They still want to keep their discretion to approve some PD cases. So I don't know what the facts and circumstances of your background is and what happened in removal and what you have on your record. You can contact us for a second opinion, of course, but we continue to maintain hope for the cases that we have pending as well, and we do have PD cases pending. Okay, let's see. My friend filed an I-765 and an I-131 concurrently. The work permit was approved, but the I-131 was not. What is next? I don't know. Why was the I-131 denied? What reason did they cite in your friend's letter? Okay. I'm not sure how to answer that one without more details. Okay. Nadine says she has her 10-year green card from 2021. Can I apply for citizenship now? Nadine, how did you get your green card? Who filed for you? What's the basis? So the way that it works is that there's early naturalization that's available for individuals who had gotten a green card through a spouse. And then for most everyone else, it's a 5-year wait time, so to speak. How much should a lawyer cost if they represent you? I don't know. There's no fee schedule out there that applies to every lawyer. Find a lawyer, have that lawyer quote you a fee, and if you like it, you like it and can manage it. If you can't, then find somebody else who could fit your needs. But there's really no answer for a question like that. And certainly it will depend on what type of case that you have. Charlene says, I filed an I-130. I did my I-130 8 years ago. How long do I have to wait for a green card? Charlene, what's the category that you're in? You're in a family preference category, because some categories do take 10, 15, 17 years. It just depends on the category. Okay, so Elisa says in the super chat, my I-601A and I-130 have both been approved. Great. Is my husband also going to the Philippines with me for my interview? He is American. We currently live here in the U.S. How many months wait in for the interview. Manila, I'm not sure I don't know what the timeline is, how long folks wait in the queue. After being documentarily qualified in Manila, off the top of my head, we have one of our attorneys handles all of our consular cases. She's the expert on that issue, but on those issues. But your husband, it's fine for him to go with you, of course. That would be great support, moral support, to go there with you, to support you. As far as going in with you, that's gonna, the agent, the Manila will have to make that decision and also speak with an attorney about that. Strategically, it's not a great idea for some spouses to go into the interview with their beneficiary partner. We've seen situations, some people come to us after having done that and it really backfired on them. Because the embassy officer turns to the U.S. citizen and begins querying that person and catches that person off guard. But that was at a different post. That was the one case that I'm thinking about in which that did happen, was the DR, the Dominican Republic. Dominican Republic. But as far as Manila is concerned, speak with an attorney one-on-one about strategy and preparing yourself for that interview. But you're almost there. That's great. Congratulations, you're getting much closer. Let's see. Another super chat question says that I'm an LPR, green card holder through marriage. I'm eligible to file for citizenship, but I got a speeding ticket last year, which I paid. Will this be an issue? Generally speaking, a speeding ticket is not should not be a major issue for naturalization. The times when traffic-related violations become a problem is if they're connected to alcohol, drugs, or an accident that resulted in someone being injured, things like that. But I think that you'll be fine. But if you have any further concerns about that naturalization application, you could speak with us further about it before you apply. All right, let's see. What else do you guys have? Let's go. I answered a question from you earlier. Is VAWA case still being approved? Max is asking. Yes. Can we travel internationally with advanced parole? Yes. Leonardo is asking, is the stepson application for stepfather taking a long time to process? No, that's an immediate relative process that you're talking about here. And so, the part of the process, of course, that is taking a little longer is the I-130. Yes, cases have generally begun to slow down, not because it's the step-parent relationship filing. No, it's just generally things have started to slow down. Mary says that she will resend an email. Great, we'll be on the lookout for it and see what the issue is. I have a 2-year green card. Can I travel back to my country for a 2-week vacation? Yes, of course. The green card allows you to leave the country and return. It's always at your own risk. I have to say that for liability purposes, of course. By the way, I forgot to mention that what's happening today, it's for general information purposes only and not legal advice. Speak with a licensed immigration attorney about your case. You guys know that to be the fact by now, by this point. We just decided to put that there. But you know what's up. All right. Okay, let's talk about alien registration. Nancy says, good to see you, Nancy. It's been a while since we saw you, I think. My I-130 application was approved. I don't know, it was approved. Do I need to register for the alien registration requirement? Not sure if this law is not active. So Nancy, the alien registration requirement has always been the law, okay? It's always been the law, and it's On USCIS's website, the form is now available for registration, and on the USCIS's website, it does list the types of cases in which people are already registered. So specifically, if you had applied for adjustment of status on the I-485 application, that process brings along with a fingerprint process. And once you have done that fingerprint, you're considered registered. Or if you, Nancy, had entered the United States with a visa, you're already registered. So take a look at the list of cases in which an individual has already registered and do not need to re-register. Okay, I-130 alone isn't enough for, based on the requirements on their website for registration. Someone says that my husband and I are both disabled. We do not have funds to pay for marriage green card, which is $3,000. Those are the filing fees. Is there any waiver requirements that can be done? I have not seen them waive the application filing fees in marriage cases. I have not seen a fee waiver for that one. Let's keep going. And that would be what you can do is look at the I-912. I think that's the fee waiver application. It has been a long time since I looked at one of those. Look at those instructions and it will tell you exactly which applications can be waived, the fees, okay? Patrick says, my I-360 petition was approved in 2023. I have R1 visa, which is expiring this November, but my priority date is not current. What options do I have? Patrick, you could potentially look maybe at an extension if one would be granted. That's one way of doing it, an extension. But this is or change of status. This is to like a different visa. Okay, different visa. This is the tricky part about things when individuals enter with the R1 and they have maxed out on the R1 and they have an I-360 EB4 process as a religious minister or whatever the case might be. You have an EB4 process going on. You want to make sure that you remain in status all the way up until the end, but there is a backlog in that EB4 category currently. So that's the sticky point. So you have to look to see whether there's an opportunity for an extension or a change of status. Otherwise, the government will not allow you to adjust your status if you do go out of status and not continuously maintained a lawful status. So we could speak one-on-one, Patrick, about your options potentially, as what I've discussed here. But of course, time is of the essence, right? Time is of the essence. Freedom now, freedom now. Let's see. Let's go. Can you get advanced parole if you have a U visa bona fide determination and have the work permit? I have not seen that happen. I have not seen that to be a possibility. But I can, if I'm wrong about that, maybe we could take a note of this. If I'm wrong about that, I'll have to ask someone here. I'll mention it on my next broadcast. But I have not seen that permitted. The advanced parole for a U visa. Okay, so all right, so deferred action and this is going to be can you talk about deferred action for out of status parents with kids in the military? She's 18, daughter is 18. So your daughter has to reach 21 to start a process for you with immigration. She's too young to do it. When she becomes of age, how you entered the United States will matter because we would be looking to see if you could do military PIP, parole in place, if it's still around then. By then, or whether you could go straight into just the I-130, I-485 process through your daughter in the military. Okay, guys, I'm gonna have to jump off here. I have to get to some paid consultations, clients waiting. Thank you again for being with me this afternoon. If you missed the first part of the broadcast in which I shared a few, maybe 3 or 4 break-in immigration news, watch the replay. Guys, reach out to us at 914-898-9488. Follow me on Instagram, TikTok, and Facebook, where I hope last week I wasn't able to do a live session in the evening, but this week I'm planning on it. Thanks so much, guys. It was great being with you, and I will see you in the next one. Bye-bye.